we're going to finish this chapter today, chapter 13. And then next Tuesday, we'll do chapter 14. And then it just makes sense to do the review Thursday. Would that work? Because that's when we come anyway. So you can work over the weekend with any questions, and then just send me questions up until the Wednesday before the review. So go back over all your notes and see if there's anything that we should go over again. And I'll be able to, the reason I'm asking this is because that way I'll be able to tell if the same question is coming up over and over again. That means we probably need to go over it again. So that helps me identify, and it helps the review session to go smoother because we can just deal with those questions. And then, of course, I'll be around all the way up until November 8th, the day of the exam. So, yeah, I think that's it. Yeah, and so the exam is just going to be, that's the other thing. By the end of the week, I'm going to post a model exam and answer key. There'll be short answers in the essay, and they're sort of based on the problems that we're doing. You don't have to know numbers or anything like that. I only use numbers so that you'll reference them, and you certainly won't need to know numbers for the MPRE as well. MPRE is a different exam. You're trying to choose the best answer. This exam, class exam, is just going to be, black letter, no tricks or anything. It'll be based on the problems that we've been doing in class. And so we started off with one or two soft classes, and now this class is going to be a soft class. Not because the material is not important. This is important material. I think you should know this as lawyers. The provision of legal services in chapter 13. And then chapter 14 is the state of the profession. So you want to know what you're getting into contextually. So that's important. But it's just not heavily rule-driven. The only thing we're really going to talk about in terms of a rule is 6.1. So just as a review of our last class, the last thing we did was the lawyer's responsibility to third parties. And, we've constructed all of these things at the beginning of our course. We talked about undivided loyalty to the client, the duty of competence, the collaborative relationship between the attorney as agent of the principal, the client. All of those things. So we have this tight connection to our client, but we also have other competing obligations. We have to function under the rules, of course. There's other law that might impact our conduct and a host of other things. And so one of the things that impacts our conduct is our responsibility to third party, which really tells us that we can't say, and this runs through chapter 12, we can't say I'm representing my client and that's it. I'm going to do everything I can to, quote, win in quotation marks or whatever. You have these other obligations. So we know we can't assist our client in fraud. We know we can't make fraudulent representations to third parties. We know all of these things. And so we did that in connection with a number of cases. We did problem 12-2, starting on page 566, the break-in. And we looked at a number of things. We looked at 1.2D, we cannot assist the client or engage a client in conduct that the lawyer knows is criminal, so breaking in, are we helping that? We talked about unlawfully obstructing another party's access to justice under 3.4. And we talked about receiving a document inadvertently. And then we also talked about the broad catch-all of misconduct. So, we shall not assist the client in criminal conduct. We have to know it's criminal conduct, but we certainly know because our client broke in. Unlawfully obstruct access to evidence. sender inadvertently received evidence and then the broad conduct of misconduct. That's dishonesty, fraud, deceit, misrepresentation. And so the question in this problem was, what do we do? What do we do? Should we destroy this evidence? We said no, of course not. Should we just move forward if the client is willing to take that risk because children are involved? And we ultimately looked at what happened in the real case. The attorney just showed these documents to the ex-husband's attorney, and the attorney was totally surprised. Ex-husband's lawyer was completely unaware, did not ask where the documents came from, and the eve of trial agreed to full custody to the mother. And also another thing think about is that probably by this time the girls were ready to testify against the father anyway. So the lawyer was so shocked that he never even asked where the documents came from. Then we did the prosecutor's masquerade. That's problem 12.3 on page 573. And we looked at whether or not there's some type of emergency exception to save lives under 1.6, and we said that's probably too speculative. So we wanted to impersonate a public defender, get all the information that we could, negotiate, and then solve this crisis. Would there be a violation of the Fifth or Sixth Amendments? We said no, but we also had a discussion about critical stages and what that meant if that right attaches. The prosecutor must not seek from a defendant who has no lawyer a waiver of rights. We said we made false statements to him. We, on some level, misled an unrepresented client. And on some level, we also gave legal advice to a unrepresented client. So we noted all of those things were problematic. In the real case, the lawyer was suspended, had to retake the NPRE, take 20 hours of CLE on ethics, and he had to have a supervisor present at all times with unrepresented persons and pay the cost of the disciplinary proceedings. He appealed and the Supreme Court affirmed. But there was widespread public support for what he did. Then we talked about the prosecutor as a minister of justice and what that means, not just getting convictions, but making sure that this broader notion of fair and equal justice is applied. And then that was pretty much the end of the chapter. But there are two things I wanted to sort of highlight. On page 580 and 581, I think we brushed over those. Now, the Michael Brown case in Ferguson really was explosive, and part of that was how the prosecutor handled the case. And it ultimately led to no indictment, and a lot of people criticized the prosecutor for how he handled the case. At some level, insulating police conduct and also not making effective assessments of witnesses that he would use to support that indictment. On page 580, that's an example of that. One of the witnesses was Sandra McElroy, and she had significant credibility problems. And she came forward as a witness in previous cases, but in those previous cases, her testimony was dismissed as a complete fabrication, and she was used in this case. And the prosecutor said he admitted that he had used her, and he decided that anyone who claimed to have been a witness of anything in the Michael Brown case should be presented to the grand jury. So that is not a proper assessment of the prosecutor's role, and shows so doubtful that it may have undermined his efforts to get an indictment. Another case is on page 581. A distinguished DA, he was a DA in LA, in Manhattan for over 30 or 40 years. Brandeis Medal winner, but this is pure politics. There was a re-election campaign, and this would happen to Dennis Nifong when we talked about the Duke case. There was a re-election campaign, and during that time, in the DA's office, it was found that one of the convictions that they got probably was not supported by strong evidence. And there's an attorney, Daniel Bibb, he brings this up, but he's told to defend the conviction despite evidence clearly exonerating the defendants. Morgenthau is in this re-election bid and doesn't want to look weak or like his office makes mistakes. Now, notice what the attorney did. The DA still continued to defend his conviction while also secretly collaborating with defense counsel and telling them what was going on. And so you see on the top of page 382, he was put in a position to defend convictions that he didn't believe in. And so nothing much came of that, and then the attorney revealed what he'd done. That's on the top of page 582. New York Bar opened an investigation of whether he had violated his ethical obligations to his client. Bibb resigned from his job. The bar investigates, but eventually does nothing without recognizing any discipline. And so ethics experts, you see in this footnote 112, they split about whether or not this behavior was wrong. So just because one commentator said just because he has a conscience does not mean he can actively subvert his client's case. Others argue that there's a higher purpose, and indeed if the prosecutor is a minister of justice, this was something that he had to do. But those are just two more examples of lawyers' duties to third parties. And that's the end of that chapter. Now, chapter 13, the provision of legal services. Now, this chapter just sort of looks at where we are in terms of providing access to justice. And I mean, when you say access to justice, we're talking about access to systems that resolve disputes, both criminally and civilly. And the book sort of talks about all of this unmet need. And one thing that sort of sticks out is that, we have this constitutional standard, Gideon versus Wainwright. It's over 50 years old. We talk about the criminal defendant's right to counsel. That's embedded in our system. But when you have that constitutional right, how do you implement it? There are a lot of limitations in terms of how it's implemented. Because if that is guaranteed to every criminal defendant and a large majority of that population is indigent, how do we provide effective representation? And we've been wringing our hands about this for the last 50 years. We have this constitutional standard, but what does it mean when you have individual attorneys with 300 cases to manage? How much equal justice is that? Yes, they have an attorney, but when you have a system that's geared towards pleas and not full exploration of guilt or innocence, what does that constitutional right mean? Gideon versus Wainwright. The other scenario is civil cases. Lower middle class, people who don't have money for an attorney, what do they do? And there's no real constitutional right to counsel in civil cases, but on some level, they impact liberty interests almost as important in the criminal context. Whether a family can stay together, whether you can stay in your home, whether you inherit property. All of these things are life-changing interests, but the courts have been very reluctant to recognize a due process right to civil representation. And you have sort of a what we call the welfare state, where you sort of provide benefits to those who cannot achieve them. What do those benefits mean if no one has access? There's an old law review article that sort of starts this type of discussion. It's called the new property. In the early 60s, it talks about the administrative state access to these benefits and what does it mean. We're looking at a case called Goldberg versus Kelly. You may have seen that in constitutional law. But all of these things are issues that impact upon us. And so there's also this discussion, and we can start here. What about alternative avenues to legal services? In other words, we're specialists. All of us, you'll pass the bar, you'll be doing something specialized. And you may not be able to reach all of the clients who need legal representation. How do you feel about sort of non-lawyers providing basic services? Like legal Zoom or filling out things. You don't need to go to law school and pass the bar just to fill out these forms. How do you feel about that? And then I'll push back on that. Go ahead and talk.
When it comes to sites like LegalZoom, in one aspect, yes, they can be helpful to people who are don't have a lot of money to pay for an attorney in just getting some basic things done. But the problem with it is, it's those sorts of sites generally specialize in just draft forms.
Right.
They're not always tailored to the specific laws of each state, and there are just some tasks that require specialist expertise that those sites cannot provide on their own.
Okay, that's good. So, and then what if I come back and say this? Well, you're making a specialization argument. There's a little self-interest in that argument. Well, self-regulated profession, a learned profession, and we don't want many people impacting on what we do. So whether it's a basic thing or a more complex thing, we have something called unauthorized practice of law, and we use that to maintain our monopoly. What about that? That's on page 596.
I mean, I've had this discussion with people before, and a lot of people who I know that are in the legal field, some of them are worried that these sorts of sites are kind of taking away potential business from them. But at the same time, they're still kind of almost guaranteed to get clients who need the sorts of services that those sites cannot provide. Especially in obviously the criminal context. I don't think you can use a legal site to get you out of prison.
So, do these sort of non-lawyer services really help in any way? I don't know if there's been any study about that, but do they actually help? So I want to incorporate a business entity in Kentucky. I don't have $1,200 to go and consult with a lawyer for 2 hours. So I'll just get the form, fill it out myself with the Secretary of State, and that should be fine. Does that work? It's not going to work every time. And then what type of representation are you really getting? So there are a lot of gaps within this system, and this chapter tries to explore that. So you see that on page 596, criminal defendants. We have Gideon versus Wainwright, which says felony defendants have a right to counsel. But as I pointed out before, there are limitations because of case law. What about accepting appointments? You see that rule 6.2 on page 597? So it says if a lawyer, say you're just walking through the courthouse, and we know that we have problems of representation, not enough lawyers to represent, even legal aid is really busy, you happen to be walking down the hall, And it just says, come here, I want you to work on this criminal defense case. 6.2, accepting appointments. What can you do there? So we're identifying this problem. This chapter takes a broad structural view. See back on page 594, and this is kind of old statistics. Law is a $100 billion per year industry. But of that 100 billion, only 1/100th of that is dedicated to delivering civil legal services to low-income Americans. So you have one lawyer for every 240 non-poor people who might need legal representation. We talk about low income who may qualify for legal aid. That's one lawyer for 9,000 potential clients. And that number may even be skewed because there are people who are low income but may not meet the requirements for a civil appointment. What about 6.2, accepting appointments? If the judge says, I want you to be on this case, what can you do under 6.2? Say, no, I'm not going to do that, I don't want to do that, or what? Yeah, Ms. Moore, I'm sorry.
Okay. You can decline if it's likely.
A little bit louder.
You can decline if it's likely that you're going to be violating the rules of professional conduct.
Okay.
Or if it's going to pose a financial burden on you.
Now, what would, that's good. So what would a rule be that would violate professional conduct? The rules of professional conduct.
Like if it's something that you don't typically practice.
Mhm.
Not in your wheelhouse and skills.
Right. You might say, I'd have a competence problem, I don't practice in this area, and even to get up to speed would cost, well, it's not even gonna cost because that's why you're being appointed as an attorney for an indigent client. So if you could point to a violation of the law, that would be one thing. Unreasonable financial burden. I mean, you're doing this for free, but in the context of your other cases and your other time, the impact on that would be so unreasonable that it will cost the lawyer a hardship to represent. So that's another way. Or the client is so repugnant to the lawyer as to be likely to impair the client-lawyer relationship or the lawyer's ability to represent the client. So that's, remember we were talking about conflicts? That is a material limitation. In other words, there's just no way around this. You can't really meet with this person. There's no way that there could even be a collaborative relationship, so you couldn't represent there. So there are instances, the book makes the point that you can say, well, you can't accept that appointment. But the prefatory language in 6.2, it urges lawyers to accept such appointments, except for good cause. And what we were just talking about were those good causes. Now, what about adequate representation in death penalty cases? And that's a real problem. We've seen cases before where it's sort of sketchy and inconsistent about how people are represented, even when everything is at stake. And we saw how high the standard was in Strickland, very deferential. Oftentimes the lawyer's conduct is affirmed as purely strategic. Courts do not want to get into determining how a lawyer should have handled the case. So if it's some baseline competence, the courts are really very deferential. But the book on page 597 even says that it's a mixed and uneven system that lacks level oversight and standards. So there's no uniformity in terms of standards in capital punishment cases. And the only real way to enforce appropriate standards is through ineffective assistance of counsel cases. And that pretty much is not the way to do it. And it really sort of points out how deficient representation is. Now, the book makes the point that appellate representation is at a higher level, and that's because you usually don't have just individual attorneys. You have attorneys who are connected to some public interest entity, like Brian Stevenson, for example. He's not just practicing in law, professor at NYU, and he has connections to his own organization, Equal Justice Initiative, and other entities like that. So appellate work, quite interestingly, is at a higher level. But think about that. You're already at the stage where something has occurred that may have led to a wrongful conviction. You're still in the system, and you have to wait for this appeal, and these appeals take years. Now, this is a good review. Look on page 598. There's an example there. Can you point to some things that this lawyer did wrong in terms of the rules that we have talked about before? We have, and there's obviously something a little bit off. You see the picture of him on page 599. That's him defending himself at his disciplinary hearing, and he dresses up like Thomas Jefferson and comes in. So that's bad. But he represented a client on death row of Philip Chatham, murder trial in Kansas. And notice this, so we have something that we can work with. This attorney, his client says, I have an alibi. I was somewhere totally different. I wasn't even in the state, so I could not have committed this murder. Murder happened in Kansas, and he says he was in Chicago. So go through, sort of as a review, go through what this attorney representing a client on death row did that was wrong. I mean, he was ultimately disbarred. So what is the conduct that led to his disbarment? So another way to look at it is if you had to establish an ineffective assistance of counsel claim on behalf of Mr. Chatham, what conduct would you point to in order to say that he's entitled at least to a new trial because of what the attorney did? It's a lot there that he did. Some of the stuff I don't even understand why he would do it. Yeah, Mr. Manager.
Yeah, I mean, talking about prior manslaughter convictions and saying he's a shooter of people.
Yeah, so that's crazy. So that's a competency. That's a sort of a graphic illustration of lack of understanding of evidence. He inserts propensity evidence on his client that allows the jury almost to say, well, even if he didn't do it this time, he did it before. He's that type of person. So this criminal defense attorney actively exploits the propensity inference, which should be prohibited against his own client. That's strike one. Anything else? So he incriminated his own client. Anything else? Yes.
Doesn't sound like he was competent because he didn't even know how to look up the phone records to establish an alibi.
Yeah, now that's basic. That's the key to the case. Alibi, how do you substantiate that? You do that with phone records. I was in Chicago, not Kansas City, Kansas, and the attorney did not follow up on the alibi simply because he did not know how to get phone records. And maybe that is complex, but you can ask somebody, you can call the phone company, you can do any number of things to try to get these records. So he didn't follow up on the alibi. He incriminated his own client. He argued that his client should be executed. Yeah. See how he could do that. And on top of that, he charged $50,000 for doing nothing. So that's 1.5, and you know that's clearly out of whack for what he did. Not talking about results, it's just his general competence. And then he did something else that is prohibited. He had the client sign a release insulating him from any type of professional responsibility or disciplinary action. And so Chatham, of course, is sentenced to death because of this representation, but he gets a new trial, finding merit in his claim that he did not have effective assistance of counsel. So notice that that conduct was so bad that it even met the standard for ineffective assistance of counsel when you have the court being very deferential. There's nothing to defer here in terms of the client, in terms of the attorney's judgment. I mean, there's nothing that we can say is strategic or anything. This is just bright line incompetence. So the book is making a point that representation makes a difference. There's another short example on the top of page 599 where you have a lawyer botching the case because of alcoholism, drinking a quart of vodka every day during the trial. And so, and stealing money from another client, I guess, to support that habit or whatever. And this attorney, Andy Prince, was disbarred and even imprisoned for a few months after the trial. But it seems like even with that, the client was sentenced to death and executed in 2014. Now notice how rigid the system is. There's certainly probably some ineffective assistance of counsel there, but the system didn't get to it quick enough and this person is executed. And then you see the footnote 34, in deportation hearings, that's sort of in line with what we're talking about, civil and administrative hearings. Just making a point that representation makes a difference. So if you see someone who's going pro bono, that doesn't necessarily mean it's going to be a bad result, but representation makes a difference. Even in deportation hearings, it says in cases on the merits, 20% of those with representation won and were not ordered to be deported, compared to only 2% who were unrepresented. So it certainly makes a difference. Now, what about this argument? So we have, even though it's imperfect, recognition that if you're a criminal defendant indigent, you are entitled to representation, constitutionally guaranteed, because the liberty interest is so important. Now, why can't the same argument be made in terms of civil proceedings? And there's been argument back and forth for years about, well, why don't we recognize a right to counsel in civil cases based upon a due process clause of the 14th Amendment? What is that case? Look on page 600. Robert William Crass. And the case ultimately leads to U.S. versus Crass. So here's someone who is fired from their job, and from that, a number of devastating things occur. So impacted financially, can't afford access to courts because of that lack, can't even pay the fee for bankruptcy to clear his debts and get a fresh start. And so this is sort of an implicit argument that these things are so important that indigent civil defendants should have a right to counsel as well. What does the court do with that argument in U.S. versus Crass? And why is there a distinction between divorce cases where it seems like a little bit of that right has been recognized, and Crass's case where you have some devastating things occurring, all of these deaths and everything, but the court says that's a little bit different. Courts have been very reluctant to expand a right to counsel in this area. Very reluctant, from a constitutional law to expand due process guarantee. Yeah, go ahead.
I just thought it was interesting that
Yeah.
they made such a, like, I don't know, an exception for divorces, I guess.
Yeah.
So
That's
the
right.
reasoning, I guess, was that, marriage is unique and involves, interests of basic importance, in society, but like,
Right.
marriage isn't the only way,
Yeah,
that we hold these values, so I didn't really follow their reasoning.
Right.
So I just thought it was interesting.
and then, but then the next step is that marriage is so unique that this is the only way to dissolve it. The only avenue is through the courts. So we'll make an exception there because that's the only avenue for resolution. Yeah, go ahead.
So is the argument, for why they don't entitle you to some kind of counsel for civil cases, is it because, the courts aren't like the only avenue for?
Yeah.
Is that the whole reasoning?
Yeah, partly. Well, no, two things, I think. One is that it just seems generally that courts are really reluctant to expand and recognize this right because then, once you do that, that right has to be implemented. It has to be embraced. It has to be substantive. And so we may have the same problem that we have in the criminal law context, like with Gideon versus Wainwright. Yes, we have this constitutional right, but how do we implement it and we fall short? In the civil context, there is this reluctance because you would be expanding the right and then how will we implement that? And so the court in the Crass case makes a distinction that divorces can only be resolved through the courts. Debt collection and these other life occurrences like contract disputes or anything that's personal can be resolved in different ways outside of the court. So resolution of them is one thing, but I think primarily what drives it is the liberty interest is so profound and different that courts are willing to accept that there has to be a right to counsel there. Civil seems less onerous. There isn't the stigmatization that goes with being convicted of a crime. There isn't loss of a liberty interest, and there are multiple avenues to resolve these issues. So, and I just, a long-winded way of also saying there is a clear bright line between criminal blameworthiness and civil disputes. In civil disputes, you don't have the stigmatization of blameworthiness, and so there are other ways to resolve those disputes. And I think the slippery slope argument comes into effect as well. Once we start recognizing these different rights to counsel, where does it end? So we can pick and choose and say, well, divorces are different than welfare benefits or Social Security benefits. But how do we draw those lines and how do we limit it? And then what will that right to civil counsel mean? Ms. Harper, go ahead.
I still cannot logically agree with the first reasoning here because they say, oh, there's all these other avenues. Not in deportation hearings.
Right.
Mediation itself is generally done by attorneys who are trained in mediation.
Right.
Like arbitration, this is all those sorts of disputes. So their own reasoning goes against them because divorce is not the only thing that can only be settled in court. There are other civil matters that can, again, only be settled in courts, especially when you're declaring bankruptcy.
Uh-huh.
Like we have a whole court system that is dedicated to bankruptcy. So how they can say, divorce is like so unique that it can only dissolve in court, that makes no logical sense to me. Then you have all of these counterexamples, like these are also things that you're saying that you're not entitled to counsel, but that can only be resolved in courts. That goes against their own logic.
Yeah, on some level, and so I think they try to answer your critique, and I don't think they're successful. But it says, however unrealistic the remedy may be in a particular situation, there are other avenues. So I don't think that their distinction holds up either, because divorce is on some level like any number of important events in civil life that have to be resolved. And it shouldn't really depend on sole access to the courts or other remedies. You have to look at what the right is. And if you have a right in the criminal context, perhaps you should have a right in the civil context if you don't have the money for access to resolve those issues. So you have on the top of page 601, the Constitution requires appointment of counsel for indigent civil litigants only when the proceeding without counsel would be fundamentally unfair. So there is a line of cases that says we're not recognizing this as a substantive constitutional right, but if we look on the record and say, well, this is an issue of fairness, then counsel should be appointed. And you know what happens when you have that type of right. Very rarely enforced. You see that on the top of page 601. So in that case, you had, again, something very important and fundamental. The state was trying to terminate an incarcerated mother's right to child custody. And the Constitution requires appointment of counsel for indigent civil litigants only when proceeding without counsel would be fundamentally unfair. Now that's sort of recognizing a due process right, but not fully embracing it. So you're allowing discretionary power to determine whether or not something really is important at play, and then saying that counsel can be appointed. And as Professor Brody says, it's very rare. Courts have applied in such a restrictive fashion that counsel is almost never required in civil cases. So there's this argument for civil Gideon, it's called. Now let's say we are fortunate enough to adopt a civil right to counsel. How do you think that would be applied and implemented? So I'm asking, if we adopt civil Gideon, we have not only a right to counsel in criminal cases, but a right to counsel in civil cases. How would that look, and how would we guarantee that constitutional right? I'm sorry.
I will say that I can kind of see why the court is trying to avoid that, because there are so many different avenues of civil litigation, and the context of the legal question itself, where lawyers tend to specialize in like certain areas of civil litigation, like one might specialize in tax, one might specialize in tort, one might specialize in contracts. It would be very hard to like create some sort of public office where, you know, like you assign a lawyer to a client who may have a problem that's not necessarily in the lawyer's area of expertise. It's not the same as in the criminal context, where a criminal attorney is generally like specializing in all areas of the law, whether it be murder or misdemeanors. So implementing it would be difficult in that there are so many different subcategories of civil litigation.
And that's good. So we sort of have a system like that, but it's really limited. We have the Legal Services Corporation, on page 602, civil legal aid. So people who cannot afford representation in civil cases, there's a network of salaried legal aid lawyers who provide advice and representation. So the legal aid that we have here and in other places, they may receive money from the Legal Services Corporation that could help with that representation. And it's the largest single source of funding for civil legal aid for the poor. But the problem is, since the early 90s, administrations have been cutting the budget there. And the Trump administration even proposed getting rid of it in its entirety. There was a fight about that, but it was managed to be saved. But very limited, and if you look at the footnote 45, very limited in terms of the services that can be provided. So notice there's a conscious effort to limit the scope of representation and to limit proactive efforts by attorneys to impact the law in a positive way for their clients. So no real advocacy, no discussion about changing the law, no pure pro bono efforts to reform or revise the federal and state welfare system. So it can't participate in any representation of undocumented immigrants seeking asylum. No participation in class actions, so there's a big uproar about that because that is one of the major avenues to initiate major societal change, and they're prohibited from doing that. So that is a problem. But what do you think this civil right would look like? So you have sort of a network of legal aid attorneys, law clinics like the one that we have. They do a little bit of the work. Students in law school clinics contribute about 3 million hours a year, and that's worth about $150 million to uncompensated service to poor people. But there still is a huge gap between the representation that's provided and what is needed in society. And also, it's an interesting thing with law clinics. You can take on good cases, but if you are sort of in the context of a university, there could be a pushback if you take on, quote, the wrong type of client. Say you have someone on the board of trustees and they don't like this type of client or this particular cause, there could be pushback, and then you have all of the conflicts issues that we're talking about here. Our independent judgment, how do we represent clients? Should we let a third party, even though we work for that third party, interfere in the representation of the client? So all of those things are real. That's on page 603. Now look at rule 6.1. Voluntary public service. And so we really have to cover this because we're one of the first schools in the nation to require public service. And so we do it academically, but then when we discuss it in real life, there's some practical implications. And there's always been this discussion about mandatory pro bono service. And it's never passed. We get up to start talking about it, and then the legal profession says no. So the way that Rule 6.1 is set up, is aspirational. This is something that we want you to shoot for as a lawyer. Voluntary public service. So someone take me through 6.1. Tell me what it says and what you would have to do as a newly admitted attorney. This is on page 604. So one thing, like a lot of the rules that we have here, it starts off mandatory, but oftentimes ends up discretionary. And it says this: every lawyer, so it doesn't say shall, but it says has a professional responsibility to provide legal services to those unable to pay. So how does the rule say you can do that? rules say you can do that? And so, you look at the comment. So every lawyer, apart from social position or professional prominence, has a responsibility to provide legal services to those unable to pay. ABA urges all lawyers to provide a minimum of 50 hours. And this is aspiration. What about that? Why do we have this rule and we're kind of like, oh, good, great, go ahead.
Okay, so if it's aspirational, I'm just assuming there's no type of enforcement for this, there's no repercussions. That's exciting. I love that.
Well, and we're laughing. This is explosive though. There's been several attempts to say, look, we can at least, it's only 50 hours, we'll make it mandatory, and then the discussion starts going, and then there's this huge pushback, and then the ABA says, okay, it was just an idea. And so it happens. It's happened many times. I don't have any real hope that it'll ever be mandatory, because we're sort of independent. And some people make the argument, how can you tell me to practice law? You're compelling me to do this, and this is sort of touchy-feely, nice stuff, and this doesn't really have anything to do with practicing law, but it should be a component of practice, and that's what the rule is trying to get at. But you're right. What's the purpose? Well, it's sort of a signpost that this is something we would like you to do. We know that there's difficulty in making it mandatory, so we'll make it aspirational. Yes, go ahead.
I can understand why it's difficult to make it mandatory because, and so I understand the pushback is probably not coming from a lack of wanting to do it. It's coming from a lack of having the time to do it, because already in practice of legal profession, especially in like criminal context, we are dealing with like overburdened caseloads. So where are you supposed to find the time to be able to give the same kind of level of competent representation when you're doing public service? Because you want to give just as much you want to have just as much competence when you're like doing public service work for like a charity or an organization like that as you do when you might be representing a client in a private litigation setting.
So tell me what you're saying about standards. So even if you're not paying for it, what are you saying about it?
It seems like if it's made mandatory and lawyers are already overburdened, then the standards are going to have to logically be lower for one setting than they are for another. And generally, the way that will probably play out is that it's going to be lower for a public service setting than it is for a private litigation.
That's true. So you think that making it aspirational, that a lawyer is going to sort of self-select the type of cases he or she wants to do for no charge, and the level of expertise and competence will be the same because the lawyer chose to be involved in that rather than it being compelled to do that.
I think that would be the ideal scenario, yes.
Okay. Mr. Manning, go ahead.
I was gonna say, I can see it being more difficult for people in private practice, but some firms that do billable hours will actually let you count your 50 pro bono hours towards your billable hours.
Right.
Gives you a real incentive because you can pick whatever you want to do.
Right.
And still have it count towards your mandatory hours.
Mm-hmm.
So.
And a lot of firms, I know, I practiced in the Stone Ages, but even then, our firm had there was a partner who his whole line was pro bono. And so, and they treated it as a regular case, no diminution in what we would do on that case, and that was your time, and I billed that time as a public interest time. So I did a school desegregation case in Alabama. They let me leave for like a month, and I worked with the NAACP, and I was just, civil rights law was just something that was developing then for me, but that was my pro bono work, and it was billed the same way as regular work, only that we weren't charging the NAACP or anything for my time. So that's a way that major firms do it. They will even have a partner who that is what he does, and it shows that how serious it's taken. So there are ways to do it, but I think the problem that you run into is when you mandate something, we sort of push back at rules being imposed upon us. So that is where we are. Notice in the chapter, it's difficult to ascertain how many lawyers meet or exceed the ABA's aspirational 50-hour standard for pro bono work. And so there was a survey in 2012, and it showed that lawyers averaged about 56 hours of pro bono service per year. And the median number was about 30. So when you have something like this and it's not mandated as part of our licensing, then that's probably what you're going to get. But you see that there are also guidelines about how much of this 50 hours should be devoted to people of limited means. We use some of this language, if I recall correctly, in terms of determining placements that we do for our own public service program. So you have persons of limited means. You have civil rights, civil liberties. Public organizations. Specific causes like the First Amendment, environment. So it's an aspirational guideline also with suggestions about where that time should be spent. You see that on page 604. Now, look at this problem. So you have on page 609, a full, Professor Rhodey is probably the expert in terms of legal professions and pro bono work and the structure of the legal system. So that's why she figures so prominently in this discussion. But on page 609, you have arguments pro and con for mandatory pro bono. And so in favor, we have special privileges. We're the only one who can provide these legal services. We're highly specialized, and we should share our talents to open up legal access to disadvantaged communities. We have a special responsibility to improve society, exposes lawyers to ways that the legal system fails, and maybe we can improve that if we know that it impacts people who have little or no power. And it benefits lawyers by providing valuable training. Now again, if the valuable training argument is great, but you can't use that as, well, this is a second level type of case and we'll just let a junior associate work on this because that junior associate will get experience and we're not charging them anyway. That isn't the approach. It has to be treated like this is just like our regular line of work. We want you to build skills in diverse practice areas, and we want you to be able to understand diverse communities that may be part of your clientele. That's important. So those are all the arguments in favor. And then the argument against some people say compulsory charity is a contradiction in terms. In other words, in order for this service to be meaningful, it must be voluntary and cannot compel altruism. Other occupations don't have such requirements. Grocers are not required to feed poor people. Forced labor is involuntary servitude. That's pretty extreme. Most lawyers would evade a pro bono requirement by providing free service to middle-class individuals, including friends, and to institutions such as museums and churches. That's interesting. That's sort of partially, but notice it's sort of a certain type of clientele and not the clientele that really needs it. Museums and charitable boards, they have access to counsel. Forcing corporate lawyers who have not trained in poverty law or in how to relate to low-income individuals will result in incompetent service. That's only true if you treat it that way. I mean, if you start from the presumption that this is lower level representation, that's what you're going to get. If you say that you should be adequately trained.
We're your fan club up here.
If you say that you're going to be adequately trained, that's part of being a fully practicing lawyer. And then finally, requiring all attorneys to contribute minimal services of largely unverifiable quality cannot begin to satisfy these nations' unmet legal needs, but may deflect public attention from more productive ways of addressing them. So that's sort of the process, procedure, neutrality argument, and it's also the slippery slope argument that if we start doing this, we have to do more and more, but then you sort of have to start somewhere, so that's part of it. So that leads us to this problem. Problem 13.1, mandatory pro bono service. So this is interesting because this happens. So I was talking about the discussion that we have. You know, it starts every 10 years or so. We have should this be a mandatory pro bono? I'm sure, like around the presidential election or a little bit afterwards, we're going to start this discussion again. Never fails. And so the question is, should we have mandatory pro bono service? So this really happens. Each year, 3 law students are elected to serve as members of the House of Delegates of the ABA. And the ABA this is the highest governing body. This is where policy comes from. So these rules that we've been studying, at one point they were circulating to a committee, then it goes to the House of Delegates, then it's voted on, and then it's sent out to the states as model rules. And then we had ABA Ethics 2000, and there was a divided debate about making pro bono service mandatory. That proposal has been, notice what the problem says, that proposal has been brought up once again, so this is nothing new. An ABA committee has recommended that Rule 6.1 be amended to make service mandatory with a 25-hour buyout. $25 per hour buyout. I guess you'd be 25 times 50 and you could buy yourself out, I guess. And the House of Delegates is scheduled to vote on this matter. How will you vote and why? Will you vote for a mandatory pro bono service? Notice that you would be imposing another requirement on you, and we'd have to set up a framework for monitoring that, because if we make it mandatory, it would have to be meaningful. It can't be like it is now, aspirational. We don't know how much lawyers spend on it because we have to do surveys, and those surveys may not be readily verified. Mr. Johnson, can't you?
I just want to, I don't really have an answer, but I wanted to ask about the buyout. Where does the money go? Who do you pay? You pay the ABA?
Well, I guess if they set it up that way, that maybe the ABA as part of dues, but I think in order to make it really work, it would probably have to be connected to some state bar association, and then you set up some type of monitoring, and then that money would go into a pool for legal education and maybe pro bono efforts. So that would be something that would have to be determined. If you make something mandatory, that would be how you implement it. So one or two places, maybe the ABA, but that wouldn't reach everybody because not everybody is a member of the ABA. It's probably more through state bar associations. We'd have to come up with a set of rules to implement it, and then a reporting system, and then a collecting system. But that shouldn't stop us from pursuing it. So what do you think? Should we have mandatory pro bono? Coming back to you.
I guess, I mean, sure, yeah, but I mean, they make a lot of stuff mandatory that we don't want to do, right? So all they have to do is just say yeah, right? So I don't get why it's really a problem to me. If they wanted to do it, they could do it.
Oh, well,
right?
they could do it, but you could have our profession enough. Well, they would have done it already if it was that easy, first of all. And
Yeah.
then every time that they try to do it.
So they don't want to do it, right?
Well, to do it would be controversial because you get pushback in all of the arguments that we talked about. The major argument is you're compelling me to do another different thing. I've already satisfied all the standards of competence, education, past the bar, past the NPRE, and now you're telling me I have to do this. And you're telling me about the scope of my representation. I should be able to pick and choose my clients and not have to be compelled to do so. So this whole argument about mandatory service is what gets the pushback. So yes, they can do it, but there's an instrumental question as well. If they did it, would it be effective? And the answer is probably not if you have the entire bar sort of split and divided about whether or not to do it or not. Yes, go ahead.
Couldn't you just mandate the hours, but not mandate the field that the hours have to be like specialized in? I mean, that's half the argument right there. So if you have a compromise and you pass this, you make the 50 hours mandatory, but you take away and like just tell people that they can pick and choose what it's in. I mean,
Okay, that's good. Tell me how that will work. So you have to do 50, and it has to be something like public interest, but how would we make sure that people who have unmet needs are met?
I feel like like an easy way to do it would be I feel like if you put that burden possibly partially on the client, like whenever you do client intake, and they kind of like fill out like this like waiver of emergency, which I see a lot in criminal work. If you do that for civil work, then that puts less burden on the lawyer. They don't have as much to complain about. They fill that out, they show like reasonable need, and then you file that with your hours.
Okay, so that would be, that's interesting. So it wouldn't look that mandatory. It would be more like a requirement of these 50 hours. I practice in this area anyway, and if I can identify clients in my client base, then I can do that. I'll check off my 50 hours. So even if I work at a corporate firm and maybe a public interest organization or a charitable organization comes to me, we really can't pay your fee, could you do? Okay, I'll do it, and then that could be part of my 50 hours.
Right. I mean that also kind of facilitates like collaboration among the legal community, which I don't think is ever a bad idea.
Right.
So yeah, I mean I don't know why I'm so excited about this, but like I feel like
I'm glad. That's
why
good.
haven't we done this? Like why haven't we done this?
But then don't you have a little problem though? So if
Oh, no.
and I'm not.
I was prepared for this.
No, so I'm not casting aspersion at any major firm or anything. So let's just say a major downtown firm, and they want to adopt your approach. It's not really compulsion; it's a requirement. We have some clients who can't really pay or don't really pay. But the type of clients that we will run into maybe is like the art museum or the zoo or the orchestra. And that's fine and good, that's public interest, but what about the unmet need that we're also talking about, the truly disadvantaged client who needs representation in civil matters? How does your solution work in that context?
So I think it balances out because
Yeah.
not every firm is a corporate firm.
Right.
Not every firm specializes in that. So there is a lot of unmet need. It's unrealistic to think that we're going to ever meet all of that. But I think it's interesting, like the corporations that you just talked about, like the zoo. I mean, they're public interest organizations, and they offer things to people. So like if they're not represented, then we're not offering society like the things that those organizations offer. So I think even that, even though that's kind of like casting a little bit of doubt possibly on my idea, I think more than anything it reaffirms
good. And so somebody, you shouldn't feel bad, like something like the library. We really need, like that main library downtown is much more than a library. It's, you know, not where somebody lives, but where you can get access to computers, data. Some people spend their day there, the older people who really are transient. So it's a true public space. So representation there is beneficial as well. And also maybe if you have this mix, you'll have small and middle sized firms that would take up the slack. So they would be representing people who might say, well, I can't really afford this, and you could do it that way as well. And they'll have more civil things that really need attention that attached to that liberty interest, like Social Security hearings, custody hearings, all those different things that impact major avenues of life. Ms. Hart.
I love what she's saying. I think it's a really good start, but my issue, the only issue I have with it is still what I was talking about earlier, the time constraints.
Yes.
The caseloads that we're already going to have, regardless of what specialization we're in, still having that time requirement. I mean, yes, there's probably a way that, you know, if you work in a big law firm that has that sort of billing hours factor in,
Right.
you'd be okay. But for people who are like private practice or in smaller law firms, they might not have that luxury, and if they're already overburdened with cases in a private context, then having to dedicate so much more time to like public service, that's not only like, again, kind of messing with standards a bit, that could also be detrimental to the lawyer themselves, because that means there's like literally no time left for them to take care of themselves so that they can make sure that they can continue to give competent representation.
Yeah, that's true. That's true. But do you think that the caseload problem is as stark as it is on the criminal side, or are we talking about a different sort of body of cases? That's something to consider, caseload and management and that type of thing. Go ahead, yes.
Okay, so I think I'm a lot more cynical
Yes,
about
that's
this.
good.
So I think maybe, like, way more cynical. I worked for one of those firms a long time ago that felt like it was, you know, involuntary servitude, and they would get really angry about having to do their pro bono hours. And that was, you know, I mean, we all aspire to help others, so that's not ever enjoyable to listen to. But that being said, I think people like that in those firms are going to find ways to get around the mandatory requirement somehow anyway. They're going to pay juniors to do it for them. They're going to try to get around it, and I don't know if it really serves people or organizations we care about to force people who aren't even interested to do it. So I sort of like it's aspirational, but there's going to be another way to fund that.
There's a value in it being voluntary because of the effort that will be involved if an attorney's picking what he or she is going to be involved in. Also the level of skill, also the time, and so when you impose something, and also when it's voluntary, it's more like it's just one of the regular cases that you're taking on, so the same level of skill and requirements. So I understand that. That's the institutional structural argument that if you compel something, there's going to be pushback, and you're going to get what you really. You're going to get unintended circumstances, unintended consequences, because you hope to do something well, but there'll be pushback, and that can undermine the type of representation that you're getting.
So also, I just want to go
Yeah, go ahead.
They had plenty of clients that didn't pay them anyway.
Right.
Like, so they would essentially be like, well, that was not pro bono. I
Yeah.
didn't pay for this case anyway.
Right.
And I don't know if that, you know,
And those were kind of clients that maybe weren't paying, but there was some other type of benefit down the line that, or a connection or something like that. And so, and you can't really quantify that, so they're not losing anything. That's interesting. Ms. Moore, you have your hand up.
I'm kind of guess somewhere in the middle where I would think that it'd be too far-fetched to require it, but there
Yeah.
should be some kind of incentive program for people who do pro bono hours.
Okay.
Like maybe a rating, like a Yelp. If people go online and look up lawyers, you can kind of make sure your lawyer has some kind of soul.
So how would that, how would you get lawyers interested in that, though?
It would just have to be a popular rating. Or, I mean, I guess you can mandate a rating card.
So do you think, sort of like what we do here at graduation will work with, attorneys? If you do this certain amount of hours, you get this certain recognition, or what do you think?
No.
No?
But if it inhibits their, people who come to them, their customers, it might make a difference.
Bob?
Okay, this might be a silly question, but so say this is imposed on like a plaintiff's firm, so contingency fee. If you say you have to represent them, it ends up going to trial, you spend $110,000 in case expenses. Is it not considered pro bono if you take part of the verdict and just for case expenses, or can you not?
Oh, no, yeah, it doesn't have to be totally free, because, look, even in the rule, it says substantially reduced fees.
Okay, so you
So-
can get back
Oh, yeah.
anything you spend on it, probably just not like a profit.
Yeah, exactly. So long as it's not a profit and it can be in kind, because that's an important question, because I don't think it'd be realistic to say everything is free. Nothing's really free, because you're sort of giving up time, effort, money, other opportunities to practice on things that could bring in a profit. So yeah, that's good. That would be under the category of something substantially reduced fee, and that still qualifies as pro bono. That's good. Anybody else? I'll leave it there. And we'll come back on Tuesday and finish up. If you have any more questions about this chapter, we'll do that. And we'll finish the last chapter. And then Thursday will be our review, next Thursday, a week from today. So during the weekend and between now, start compiling questions and sending them to me. And I'll start working out. I'll give a reminder to you in our Tuesday's class.